Morning, Your Honors. The matter before the court this morning is the case entitled Katerina Nolan as Administrator of the Estate of Parker Berry v. Stephen J. Fishman, docket number 2018-261. Representing the appellant, Stephen and Susan Fishman, is Susan Flynn. Seated at counsel table with Ms. Flynn are Stephen and Susan Fishman. Representing the appellee, Katerina Nolan, as Administrator of the Estate of Parker Berry, is Andrew Beerworth. Seated at counsel table with Mr. Beerworth are Sarah Cornwell, Katerina Nolan, and Josh Berry.
Thanks very much. Counsel?
May it please the court.
Good morning.
Good morning. This lawsuit arises out of the very tragic death of a toddler who wandered away from his daycare provider and drowned in a section of the Thatcher Brook that runs through the property of my clients, Susan and Stephen Fishman. Plaintiff appellee has argued in the context of this lawsuit that the Fishmans somehow owed a duty to better protect the toddler, Parker Nolan, from that tragedy. Although the matter is truly unfortunate, neither the common law nor Vermont's recreational use statute gives rise to a duty of care under these circumstances. So let me briefly talk about the common law. Under the common law, we found no precedent that supports that landowners like my clients owe some kind of duty of care to protect others from a natural, undeveloped body of water like the Thatcher Brook.
So when you talk about the common law in DeMag, we really moved the common law forward toward the sort of evolving modern view around duties owed to people who come onto your land with authority. And we adopted a standard of reasonable care, a duty of reasonable care, which then shifts the analysis from a legal duty question to a factual standard and breach question. If you look at the restatement third, which is what embodies that notion, it specifically says that that may encompass a duty to protect people on your premises from natural conditions, although the fact that it's a natural condition would be a significant factor in determining whether or not it's reasonable for you not to have taken steps. Why isn't that the law that we should be following?
Because no courts have found it appropriate to impose a duty of care under those circumstances. And I would submit that the attempt by the plaintiff appellees to move this case away from natural conditions of the land, which is the basis for imposing liability on landowners in this state under, I'll pronounce it poorly, but I think it's the Chiquion case that has not been overturned. But they want to move the standard of care away from the condition of the land into some more generalized, abstract duty of care, which is in essence then a duty to protect third parties from harm. So that
It's a duty to take reasonable steps, which when you consider whether it's a natural condition and what the costs would be and what the benefits would be, may well result in a determination that there is no duty.
Well, it has to be duty to take reasonable steps as to what? I think what is being advocated here under the common law is that if you have a situation where somebody's on your property, it goes to the jury as a matter of law because there's this vague idea that there could be a duty of care under those circumstances. What I am suggesting is that there are situations where no duty of care can be implied under the common law, and this is one of those situations. Courts have not traditionally found duties of care associated with natural, unimproved bodies of water like the Thatcher Brook. And so what is really being argued here is that the defendants had a duty of care to protect third parties from harm, which is, again, a very, very narrow standard, as this court has held time and again. I don't think the law as it currently stands under DMOG says if you're on the property, it's got to go to the jury so that the jury has to determine that standard of care.
No, you need evidence to support the standard of care to get to the jury, and you need evidence that the standard of care was breached. And that conversation is happening within the box of what's the standard of care, not whether there's a legal duty, which as a landowner, you have a legal duty relative to your premises. Filling the content of that requires evidence, and you don't get to the jury unless there's some plausible standard that you've breached relative to maintaining your property.
Then I suppose, put that way, the question is, what is the standard that was breached relative to the property? Again, that's where we find no precedent in the case law for what is being advocated in this case.
So is this the basis for your argument that the trial court had a bias of some kind? Is that where you were coming from with that issue?
Well,
Isn't that one of your appeal issues?
Well, one of my appeal issues is that the trial court injected analysis into the summary judgment process that was not part of any of the analysis submitted by the litigants.
What analysis was that?
The trial court, in considering the recreational use statute, wanted to understand where certain structures that had been placed, temporary structures by the daycare adjacent to my client's property, had been placed on otherwise open and undeveloped land, so as to argue that somehow the presence of those structures and their precise location relative to where this tragedy occurred might take this situation outside of the statute.
Was this the teepee that was no longer there and the sandbox?
Exactly those things. Exactly those things. And I want to make an important point here, if I may, two important points. Understand, as I'm sure the court does, that this is not easy. What this recreational use statute is asking landowners to do a difficult thing. It's saying, hey, let people hunt on your property, right? Let people come and do high-risk activities like non-commercial aviation, like mountain biking, like
Well, the aviation's above your property.
well, it's a recreational use in the statute, non-commercial aviation. The point is, this statute says to folks like the Fishmans who have kept their property open to hunters and non-commercial aviation and trappers and the like, ever since they own that property, the legislature says, if you do that, we're going to protect you by giving you a clear rule that says you owe visitors no greater duty than you would owe a trespasser as long as the visitor is present on your property for recreational use and gets no consideration. So I just want to make that point that insofar as the trial court and other courts carve out exceptions to that recreational use statute, there is no clear protection for landowners, and we will see more and more posting of land, as many of us has observed is already happening. So that's very important. So coming back to the Chief Justice's question about the trial court and what was sort of added to the analysis, the trial court said, I want to know, we didn't raise these issues, the litigants didn't raise the issues, I want to know where these structures were relative to the Thatcher Brook area where the child died. Now, I submit to you that that is a complete red herring, and the reason for that is that the limitations of land, on the recreational use statute talks about structures on land. In other words, its reach, its limitations on liability extend to someone that comes on land for a recreational purpose and then uses a structure on that land. And that limitation and the distinction between the limitation on land and that on structures is found in section 5793. So as the trial court suggested, somehow we need to know where these structures were relative to where this event happened. That simply has no support in the statute. Importantly, plaintiff appellee advocates for the removal of these circumstances from the statute, arguing that there was some kind of business purpose for the decedent's presence and that that is somehow an exception under the recreational use statute. But that argument is flawed because that exception is nowhere articulated in the statute, because that exception is inconsistent with the express language of the statute, because that exception results in undermining the purpose of the statute,
So change the facts a little bit. Let's say that the folks who ran the daycare actually decided to open a roadside attraction. They charged money and they offered sort of, they had picnic tables, but a nature experience, and charged money for people who came and advertised that this was part of their land, even though, a part of the experience. I guess they didn't say whose land it was, part of the experience. Neighbors accede to that. In your view, their duty still to those people who are paying for this experience doesn't include any duty of reasonable care relative to people on their premises?
Well, if the premises are being used for a commercial recreational purpose, I don't know whether the roadside attraction analogy that you posited would apply to that. But if the premises, for example, commercial recreational purpose involves some kind of use as a ski area or a toboggan run or something like that, commercial recreational purposes don't meet the definition of land under the statute.
Why isn't a daycare a commercial recreational purpose? A daycare that includes as part of its mission outdoor activities on this land?
Because the statute doesn't care about what business purposes, what commercial purposes visitors have. The trial court recognized that expressly when it looked at the definition of recreational use and found present there guiding, something that's typically done for
Does
compensation.
it say guiding for compensation?
It doesn't say guiding for
So
compensation.
there's been an inference in the briefs that must mean paid guiding, and
Well, I think what the trial court said is that guiding, just like trapping, is an activity that often has financial or commercial ramifications or involvement, but the statute doesn't care about that. The only commercial issues the statute cares about is whether the landowners are receiving compensation or the exception to the definition of land where the land itself is developed for a commercial recreational purpose. I'm going to sit down because I think rebuttal will be important if.
Yep, sure.
Thank you all for your time, I appreciate it.
Thank you, counsel.
Good morning, Mr. Chief
morning.
Justice,
Good
Honorable
morning.
Justices, may it please the court.
Thank you.
The trial court correctly recognized that this case is about fundamental principles. Principles that bring not only common sense, but clarity and predictability to the law. Appellants raised three arguments in their brief, one of which is that the trial court was somehow biased or abandoned its role as an impartial arbiter. I'm not going to spend any time on that. I don't think it warrants much discussion. I think the record in this case shows just how carefully Judge Carlson sifted through the record. He wrestled with some of these issues in his first decision and ultimately landed where he did in his final decision. The two remaining issues in this case are whether the Fishmans owed Parker a duty of reasonable care at common law, and if so, whether the recreational use statute applies and extinguishes any duty of care running to Parker under the facts of this case.
it doesn't just extinguish it, it reduces it to willful and wanton, right?
Right, I should have said, Justice Robinson, that it extinguishes any duty of reasonable care to Parker under the facts of this case. On the common law duty issue, it's undisputed that Parker was a lawful entrant on the defendant's property at all times. He was only ever there as an invitee of the daycare. As Justice Robinson noted, this court recognized in DeMag that there is a duty that is triggered by a lawful entrant status on the land. We have never argued that the question of breach, meaning the question of negligence, is something that should be decided as a matter of law in this case. Our position has always been from the outset that this issue presents triable issues of negligence for the jury.
Can I ask you what the duty is and how it would be discharged?
Yes, Justice Eden, the duty is one of reasonable care to Parker. The defendants knew he was on their land. They knew why he was there. They knowingly exposed him and the other children or allowed them to be exposed to the brook. And they knew that the only thing standing in the way or between those children and certain injury or death was a daycare which extolled the virtues of not closely supervising children during outdoor play.
So you're saying that a brook is an extremely dangerous entity, instrumentality?
Justice Scogin, I'm saying that it can be. I'm saying it was in the circumstances of this case.
Why?
because the defendants knowingly allowed the daycare to use their property, including play in and around the brook, and they
They
knew.
don't own the brook.
I'm sorry?
They don't own the state water, right?
They don't. They own property immediately up to the brook. The brook flows directly through their property. Their property continues on the opposite side of the brook and goes up the hill. The daycare had unfettered access to their property. There were, and to, if I may, finish my answer to Justice Eaton's question as well, in that I think the duty could be discharged in several ways. And this, I think, is a jury question, frankly, but I think there's a menu of options that the Fishmans could have chosen from to prevent this accident from happening. Probably the least burdensome one was to simply tell their son and daughter-in-law to stop using their property for daycare purposes because there was an open water hazard on it. And these were small preschool-age children. That would probably be the least burdensome way. If they didn't want to do that, if they wanted to voluntarily go forward with their decision to allow a daycare to use their land, including the brook, they could have erected some sort of physical barrier. They didn't have to do that. They could have simply instructed them not to go on the property, but the barrier would be another means. And barring that, if they didn't want to put up a fence, if they thought that was too expensive or too burdensome, but they still wanted the daycare on the land, using the brook, they could have supervised the children themselves. There are a lot of things reasonable people would do, but I don't believe any person with a stitch of common sense would allow a daycare with a child care philosophy like this daycare to use their property with an open drowning hazard on it.
The law says the fact that an owner has made land available without consideration for recreational uses, which includes educational uses, which is how I deem the daycare, shall not be construed to extend any assurance that the land is safe for recreational uses or create any duty on an owner to inspect the land to discover dangerous conditions.
That's correct, Justice Skoglund.
Pretty broad indemnity there.
That's assuming the statute applies, and we can get there. But that all assumes that the statute is applicable.
Right.
And our position is that it's not.
But your argument around liability sort of flows into the statute because the theory of what's the standard of care that was breached, what was the act or omission that was unreasonable, and one of the options you gave was not allowing these kids on your land to begin with. Isn't that exactly the response that the statutory overlay on the common law was designed to militate against?
Well, Justice Robinson, I agree that does sort of lead into this discussion. And I'd be happy to jump into the statute because I think that's where the interest is here. My response to that, Justice Robinson, is that I think if we look at the trial court's decision, baked into the analysis is a couple of very critical facts. One fact is that the daycare was operated by the defendant's family members. Family members are about as far from the general public as it gets. Secondly, the daycare was...
So are you saying the statute might apply if they weren't related?
I don't think that's dispositive, Justice Skoglund. I think the next fact gets us there, though.
Okay.
The next fact being that this daycare was not a field trip type of daycare. The statute explicitly contemplates public invitees going onto land for a recreational purpose. The daycare never went onto the land. It was already there. Its operational scope extended to broad swaths of the defendant's property. It advertised it that way. It said, here's our daycare. It's based on 42 acres of family farm, 40 acres of which was owned by the defendants.
So to use the guide analogy, a guide says, okay, I'm a long trail guide or some sort of guide, and for hire, I'm going to take people through these places, which include private lands that have been held open through hikers. And I'm advertising that I'm going to take people through their land, and they are allowing that. Does that, my business activity, guiding people for hire onto their land, convert that land into sort of a business of theirs?
And if I understand your question, Your Honor, this would assume that the defendant landowner knew about that commercial activity?
Yes, and acquiesced.
I think that presents a much closer question, frankly. I don't think that's this case, but I think that's much closer to the...
Why isn't it this? I mean, what's...
The difference here is that in the paid guide example, the guide is perhaps engaging in commercial activity with his customer on the land, but both of them are still engaged in recreational purpose or activity. The guide doesn't have a business establishment on the land, though. He's there there's maybe a private commercial transaction. I think one of the things that could tip this away from immunity is the fact that the landowner knows about it. But I think this case presents a much cleaner fact pattern and something that falls even farther outside the scope of the statute, in that unlike a paid guide or someone who literally just goes onto the land like a field trip or on and off kind of thing, the daycare business in this case had a physical footprint, physical presence on the land on a nearly daily basis. And I think that business establishment is what takes this so clearly outside the scope of the
So
statute.
how do you, I mean, the statute requires consideration, and that's actually defined as money paid to the owner.
Yes.
There's no, no suggestion here that there was consideration paid to the owner. Doesn't that discuss?
So, certainly. So I think that's certainly one element that the defendants have to prove to shoulder their burden that the statute clearly and unambiguously applies to this case. And I don't think there's any dispute about the consideration piece in this case. We conceded below that the landowners were not paid by Parker or his parents.
Right, but I guess the way it seemed relevant to me is that your argument sort of leverages the fact that people are going to this daycare in a business capacity to, therefore, the use of the land behind the daycare is a commercial use or a within the statute. That's what I'm trying to figure out.
I take your point. So the statute gets at that idea, I think, in some other ways. Certainly consideration could be one. Another way is the way it excludes from the definition of land areas developed for commercial recreational purposes. So clearly the legislature didn't have in mind Walt Disney on someone's property, and many lesser things probably. I think where I keep returning, Your Honor, is this idea that in courts in jurisdictions that have language very similar to Vermont's policy statement in Section 5791 have recognized this. The policy statement in 5791 is based on this 1965 Model Act. Many other jurisdictions have that kind of language in their statutes. We've cited cases from the highest courts of Washington, New Hampshire, Massachusetts, Oregon. All of these courts have recognized that these statutes only apply to public invitees. So I think the cleanest way to look at this case is that, based on the undisputed factual record, if the defendants had decided to close their land to the general public, Parker and the other daycare school children would still have been allowed to use it because the defendants allowed their son and daughter-in-law to use the property for any purpose they wanted.
How do we know that? I mean, that's one of the arguments back and forth is that we're hearing from one side, their rights are no greater and no less than the public as a whole, and we're hearing from you that rights are completely different from the public as a whole. How do we, is there something in the record that's going to answer that question?
So yes, I believe so, Your Honor. The defendants admitted below there was no response to our undisputed statement of facts. They admitted below that the defendants allowed their son and daughter-in-law to use their property, not just for public recreational purposes, but for any purpose. So if they had closed the land to the general public, meaning cut off that purpose, there still would be the existing business purpose that they would have been allowed to pursue.
But did they cut off any other purpose for the general public as well? Were there postings saying you can come in for this purpose but not that one?
Did they do that?
Yeah.
No, they did not.
Okay, so couldn't the general public use it for any purpose?
Well, that gets, I think, Justice Eden, that gets at this argument that the appellants make about negative impact. They say that this court should impose this negative impact gloss on the statute from the Malika decision, which frankly had to do with a very different statute. But even if we were to take that argument and consider whether the daycare was negatively impacting public recreation or not, I actually think it was. Because let's consider the extent to which the public actually used the Fishman's land. The record evidence is, and Stephen Fishman testified, that over the last 3 or 4 decades, he'd seen a handful of hunters on the land. Susan Fishman testified that a bunch of neighborhood kids would occasionally use the sandbox in their immediate backyard. Well, the sandbox doesn't qualify. It's in the curtilage of the home, and even the defendants admit in their papers below that it was in the developed part of their property. So really what we have here, as far as the known public use of the Fishman property, is hunting. And Judge Carlson alluded to this in his final decision, and I think he was right to do so, by raising this problem that this case raises, which is that what hunter would be encouraged to go on this property with a bunch of kids running around? So if this court is inclined to engage in a negative impact analysis, I don't think it advances the appellant's argument. I don't have much time remaining, Your Honor, so I'd like to just end where I began, with Judge Carlson's clear and narrow rule of decision in this case, which is that the statute's purpose is not met by effectively immunizing owners who have permitted ongoing daily advertised use of their land for a private commercial venture operated by other family members, and the person injured is only on the land because of that commercial enterprise. These are the unique, I'll grant that, the unique and undisputed facts of this case. The trial court was correct in holding that they fall outside the statute. Thank you.
Okay, thank you. Does the appellant have time?
Appellant has 4 minutes and 10 seconds
All
remaining.
righty.
Thank you. In response to some of the comments from my colleague, I want to emphasize, and I think the court appreciates from some of the questions, that the Fishmans treated the daycare owners no differently from the way they treated anybody else in terms of access to their property. They had kept their approximately 50 acres open for everybody before the daycare was ever there, and they continued to keep it open for everybody after the daycare was there.
So what about the undisputed fact that they allowed their kids in the daycare to use the land for any purpose?
Well, I'm not quite sure where the any purpose is coming from.
Okay.
What the defendants did not do was impose any restrictions on their family members or anybody else for that matter. And there were, although I don't think negative impact is really the issue here, there were some poignant examples given by the Fishmans about going out and walking the property and seeing not only deer stands, but hearing shots in the distance and seeing a deer come running by. They did what the statute what the statute claims it encourages people like them to do, is leave it open without restrictions. And I can't emphasize enough that that's not an easy thing to do. It's not an easy thing to do because even when you're trying to follow the rules as you understand them to be, you can be subjected to lawsuits. And again, the statute is clear that it is looking for clear rules for folks like the Fishman that are going to be offering those kinds of protections. I also want to say that I do believe, with all due respect to my colleague, that nearly daily basis use of the daycare is not supported by the factual evidence. In fact, if you were to ask the Fishmans, or if you would look at the record as regard to what they did or didn't do, oftentimes, as was the case here, they weren't policing the land. They weren't looking at the daycare activities. They've got jobs. They were doing their jobs, and they'd come home at the end of the day without any knowledge about who had made visits or how many times they had been there. To address a suggestion to the contrary, they had no knowledge that children were there at the time that this event happened. They had no knowledge of what kind of supervision, if anything, was being undertaken at that time. They were at their jobs. They weren't present. And just finally, I don't know how much time I have left, but again, the exception that is being advanced here is some kind of business use exception. It's not in the statute. It's inconsistent with some of the recreational uses that contemplate compensation. It would undermine the purpose of the statute because it would lead to absurd results absent some kind of monitoring or inspection by property owners. I mean, think about it. Keurig Green Mountain is down the street, okay? You're there with some folks from work taking a nice nature walk so that you can discuss some developments in the company. Because you're there for a business purpose, the appellees would suggest, then your protections don't apply. those same folks?
I thought their argument was a little more nuanced, that it was areas developed for commercial recreational purposes. And the idea is they've set this up as a backyard of a commercial operation, not business people who happen to be doing business while they walk through.
Well, what we're talking about is there was a teepee at some time, that there was a sandbox, and that somehow is bringing this property, and that language, Justice Robinson, is in the definition of land section. So now those structures, temporary structures, have now taken the entire area as an area developed for a commercial recreational purpose. That can't be. I mean, think about people that come, or the guides that come, they erect a deer stand, all of a sudden, no protections there. In other words, oh.
Thank you very much.
Forget the other words. Thank you very much for your attention to this matter.
Next hearing for the court will follow immediately.